So, what does the mediation process actually look like in a divorce? That's what we're going to talk about today. I'm Illinois divorce lawyer Bobby Buchanan, and this is Illinois Divorce TV. So, mediation can occur before or during a divorce, meaning before a divorce is filed or after it's filed. It looks a little bit different depending on when it takes place. That difference is due to the fact that once a case is filed, it's on a track and it has to move forward. It's like imagine a train and there's trains behind it, and the judge is, I don't know what you call it in train world, but kind of the equivalent of an air traffic controller. So let's use planes as an analogy. It's on the runway and there's planes behind it, and that plane has to take off. It's got to keep moving forward. So the air traffic controller is going to make sure that that plane keeps moving forward. So if your mediation takes place during the divorce process, meaning after the divorce has been filed, then it's got to keep moving forward. And if it doesn't move forward, then the judge is going to start setting deadlines for the litigation process. And so it takes a different character when you have that pressure behind you. And it can be a little bit more difficult to resolve a case through mediation after a case has been filed. It can also be maybe a little bit easier because you do have that pressure and you have the incentive to move things forward. So, what does it look like before the case is filed? What it looks like is that, first and foremost, let's talk about the structure of mediation. Mediation means you and the other side, your spouse, with or without lawyers, are meeting with a third party neutral who has been trained in getting people to come to a compromise. And they do that through a certain process or a certain framework. Depending on the mediator, it's going to be slightly different, but the general principles are the same. Both parties have to be there voluntarily. So that's the first and foremost what's going to happen. If you want mediation to happen before your case, is you and your spouse are going to have agreed that you're going to try to work this out. And that requires a minimal level of cooperation. If you and your spouse can't even see eye to eye and can't even agree to show up to the mediator, can't even agree on who your mediator is going to be, then you're not in the right place for mediation. And if you want your divorce to happen, you're going to have to file your case. You're going to have to get your spouse served and you move that plane away from the gate and towards the runway. But let's say you do get to mediation because you both agree and you're able to select the mediator, select the time, and you both show up. What's going to happen at that first mediation? Well, there's going to be a portion of discovery, of figuring out what your current situation is. The mediator is going to want to know what your current financial situation is. Most of the time, you're going to have to do some prep work, probably fill out some sort of financial affidavit. And both of you are disclosing to the mediator what you have. Sometimes the mediator will have you do that financial affidavit jointly. I think that that's a good exercise. If you two can't come to an agreement on what you actually have, then mediation might not be best for you. There really has to be transparency in the whole process for it to have the best chance of succeeding. So you'll sit down with the mediator. The mediator will get a general overview of what the situation is and work on pinpointing the issues. You might say the mediator may figure out, okay, you guys agree on this big thing and this big thing, but you don't agree on this third thing. At that point, there's going to be the mediator is going to want to find out where your disagreement lies, see if you can find some underlying principles to move forward on. Let's say you both agree that you want things to be fair. Well, that is a good starting place. But what does it mean to be fair? Maybe we're talking about how to split the equity in the house, and one person says, well, I worked and I paid the mortgage all these years. The other person says, well, I I took care of the kids all these years. The mediator is going to step in as well and say, well, here's what the law says about this situation. Here's what's most likely to happen if you go to court. Now, that process and whether or not that is going to work really depends on whether or not you two can compromise. And if you're so far apart that there is no area to compromise and the mediator's not able to say, okay, well, if you're willing to give him X, then maybe he's willing to give you Y, and that brings you closer together, then again, mediation's not going to work. There are some few, so that's what mediation looks like before the case is filed. What does mediation look like after the case is filed? Well, you again will have to come to agreement that you're going to do mediation. Well, let me back up. There is a type of mediation where you don't have to come to an agreement that you're going to do it. You're just going to be ordered to do it, and that is custody mediation. In all divorce cases, unless you have an agreement or unless there's an extraordinary reason why mediation is not going to work, cases of domestic violence or something like that, and even in those cases, sometimes judges won't allow you to skip over the mediation process, you'll be ordered to do custody mediation, and you'll be ordered to sit down with your spouse to figure out what your co-parenting plan is. And there's a lot of incentives to making that mediation work, because if you don't, the next step most likely is a guardian ad litem gets appointed, and that is an attorney that you have to pay for, that interviews you, interviews the kids, interviews the other side, interviews teachers, interviews and investigates whatever they want to investigate. It makes recommendations to the judge, and you start to lose all this control over the process. You start to pay more money. It starts to become a lot more unpredictable and a lot more drawn out as well. So there's a lot of incentive to make that custody mediation work. The other sort of mediation during the court process does require agreement, and that's going to be financial mediation. So the court could order you to financial mediation, but that's only going to happen if you and the other side agree. And that usually comes from the two attorneys talking and saying, hey, what do you think the possibility of the parties working this out in mediation is? And both attorneys say, yeah, that's a good idea. They pitch it to their clients say yes, and then they get into mediation. That is private mediation. That is something that you have to pay for. It's generally anywhere from about $200 to $500 an hour, depending on the mediator. The general process once you're in the room with the mediator is the same, whether or not it's mediation before or after you filed. But when it's before you filed, if it doesn't work out, you can just come back in 2 weeks and in 30 days, tomorrow. And if that doesn't work, you come back again. If that doesn't work, you come back again. As long as you two agree to come back, you can come back. In court order mediation, the judge is going to want to see that you're making progress. And the judge is going to take the attorney's words for it, that mediation is working, that it's worthwhile, and the judge will give you some leeway. But after 60, 90, yeah, that's probably the most, about 60, 90 days, the judge is going to say, what are we doing here? Was going to want to know a little bit more about what the issues are, and may propose something like a pretrial conference. Pretrial conference is an informal conference with a judge where the judge makes recommendations, and can be an incredibly powerful way to move the case forward as well. So that is what mediation looks like in the context of before court and after court and custody mediation. Mediation is the best way to resolve a case, short of an attorney just drafting an agreement and your spouse signing it or sending it back with a little bit of redlining. Mediation is the way to resolve the case for the least amount of stress, unpredictability, expense. And a good attorney can really prepare you for the mediation process so you understand where your limits of negotiation are and make it more efficient for you. Once you go out of the mediation process and you go into litigation, then things can start to get really expensive, because attorneys can start filing motions, and maybe you have an attorney that's very aggressive on the other side. And aggressive doesn't mean effective. It just means that attorney's filing motions because, you know, that's how they practice. And then your attorney has to do the same thing to respond in kind, even if your attorney is a relationship builder attorney, which I think is the most effective type of lawyer. They're going to have to respond to these motions, and you can only build relationships so much with an aggressive attorney. Long story short, it gets way, way more unpredictable and expensive if you can't resolve things in mediation. If you found this video helpful, then I'd ask that you subscribe, give me a comment, give me a thumbs up, let me know what you want me to shoot a video on next. This is Illinois Divorce TV, and I'll talk to you soon.